All right, so a lot of people have been or posted on my video about the GSA bonds, and this is kind of something that goes along with that. And this is what I found quite interesting. So if you know somebody that's in prison, they're in there because they owe a debt to the United States, because all crimes are commercial, and there's bonds created on that case, and they're sold on the world market, and the judge is going to make 18% of what those bonds sell for towards his retirement fund. But there's a little clause in the Statutes at Large, Volume 1, Stat 561, Chapter 49. And what this says is, an act providing for the relief of persons imprisoned for debt due to the United States. Section A. Be it enacted by the Senate and the House of Representatives of the United States of America in Congress assembled, that any person imprisoned upon execution issuing from any court of the United States for a debt due to the United States, which he shall be unable to pay, may at any time after commitment make application in writing to the Secretary of the Treasury, stating the circumstances of his case and his inability to discharge the debt, and it shall thereupon be lawful for the said Secretary to make or require to be made an examination and inquiry into the circumstances of the debtor, either by the oath or affirmation of the debtor, which the said Secretary or any other person by him specially appointed are hereby authorized to administer, or otherwise as the said Secretary shall deem necessary and expedient to ascertain the truth, and upon proof being made to his satisfaction that such debtor is unable to pay the debt for which he is imprisoned, and that he hath not concealed or made any conveyance of his estate in trust for himself, or with an intent to defraud the United States or deprive them of their legal priority, the said Secretary is hereby authorized to receive from such debtor any deed, assignment, or conveyance of the real or personal estate of such a debtor, if any he hath, or any collateral security to the use of the United States, and upon a compliance by the debtor with such terms and conditions as the said Secretary may judge reasonable and proper under all the circumstances of the case, it shall be lawful for the said Secretary to issue his order under his hand to the keeper of the prison, directing him to discharge each debtor from his imprisonment under such execution, and he shall be accordingly discharged, and shall not be liable to be imprisoned again for the said debt. But the judgment shall remain good and sufficient in law, and may be satisfied out of an estate which may then or at any time afterwards belong to the debtor. And be it further enacted that if any person shall falsely take an oath or affirmation under this act, he shall be deemed guilty of perjury, and be subject to the pains and penalties provided in the third section of an act entitled An Act for the Relief of Persons Imprisoned for Debt. Section 3 says, and it be further enacted that the benefit of this act shall not be extended to any person in prison for any fine, forfeiture, or penalty incurred by breach of any of the United States, or for monies had and received by any officer, agent, or other person for their use. And so, looking further into it, under the Federal Rules of Civil Procedures, Rule 60, Relief from a Judgment or Order, corrections based on clerical mistakes, oversights, and omissions. The court may correct a clerical mistake or mistake arising from oversight or omission whenever one is found in judgment, order, or other part of the record. The court may do so on motion or on its own, with or without notice, but after an appeal has been docketed in the appellate court, and while it is pending, such a mistake may be corrected only with the appellate court's leave. So if you try to do this while you're during an appeal, you'd have to ask the appeal for leave of the courts to have this happen. The grounds for relief from a final judgment, order, or proceeding on motion in just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding to the following or for the following reasons: mistake. Newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial under Rule 59B. Canon of Positive Law. Article 142, Mistake. Canon 2392. A mistake, also known as a mistake of fact, is an erroneous belief or trust that certain facts are true when committing a reasonable action. A mistake of fact does not exist when an action is considered unreasonable. Canon 2395. In the permitted admission of a mistake of fact, an assumed surety to the liability from alleged injury ceases to exist. Canon 2399. Any competent authority that refuses to offer relief to a person upon permitted admission of mistake of fact is guilty of fraud and a gross injury to the law. Letter of Relief. Department of the Treasury. 27 CFR 19.171. Surety Notice of Relief from Bond Liability. Write that down. 27 CFR 19.171. Surety Notice of Relief from Bond Liability. That's huge. Surety of Notice of Relief on Bond Liability says, A. Notice to principal a surety on a bond may at any time. I'll start over. A. Notice to principal a surety on a bond may at any time notify the principal in writing that the surety desires to be relieved of liability under the bond. B. Notice to TTB, which is I can't even think of it off the top of my head right now, but it's basically what holds all of our trust accounts. A surety on a bond may at any time notify the appropriate TTB officer in writing that the surety desires to be relieved of liability under the bond. The notice must specify the date after which the surety desires to be relieved of liability. In the case of withdrawal bond, the date specified in the notice must be at least 10 days after the notice is received by the appropriate TTB officer. In the case of an operations bond or unit bond, the date specified in the notice must be at least 90 days after the notice is received by the appropriate TTB officer. When a surety files a termination notice with the TTB, the surety must include either an acknowledgement from the principal that the principal is aware that the surety is terminating, and the bond, or proof that the surety has served the principal with notice of its intent to terminate the bond. Effective notice. The bond coverage will end as of close of business on the date specified in the notice, provided the surety timely filed a proper and complete termination notice, and the surety does not withdraw its termination notice in writing prior to the termination date. The surety will be released from future liability under the bond to the extent set forth in 19.172. 26 USC 5173, 5175, 5176. Appropriate TTB officer means appropriate TTB officer, an officer or employee of the Alcohol and Tobacco Tax and Trade Bureau, authorized to perform any functions relating to the administration or enforcement of this part by TTB Order 1135.19, delegation of the administrator's authorities in 27 CFR Part 19, distilled spirits plants. I'm just going to smile here for a second, because I think those of you that heard what I actually read are probably like, what the fuck did he just say? Come again? Fucking fly. This fly's been bugging me all frickin' night. So, fucking, and then try to hit him with this, and then I feel like this is more of a sex toy than it is a fucking fly swatter. I don't know. Just my opinion. Anyways, did y'all get that? Because what that says is that at any time, if you don't want to be liable anymore under the bond, which you are in prison for, can write to the treasurer and ask for relief to be out from underneath that bond and then be let go. You might have to sign off some of your property, but that's a debt, right? Hope you guys took notes. See you next time.